joining us today on Facebook Live. My name is Emily Newman. I'm an immigration attorney with the law firm of Reddy & Newman PC, and I'm also the writer behind the blog immigrationgirl.com. I'm here today with my partner, Rahul Reddy.
My name is Rahul Reddy. I'm a partner in Reddy & Newman PC. We have established our law firm in 1997. We do exclusively business immigration, mostly H-1Bs, L-1s, green cards. And Emily, as we know that the Trump administration, since they came in, a lot of things have changed, and you just published an article of notice to appear. Is it like, what is this? Is it like when you apply for the change of status, when you apply for the extension of status, if you get the denial, will you get a deportation order? Is it what it is, or how does the notice to appear works?
Right, so this is a brand new policy that went into effect immediately upon it being published last week, and it does change the existing policy about notices to appear and who gets them. Now, a notice to appear is the initiation of removal proceedings. It used to be called deportations. So yes, if you receive a notice to appear, that means the government is intending to deport you, and you have to go before a judge who will make the decision about whether you're going to be deported or not. Now, typically, this type of situation, we never really had to worry about it much in employment immigration.
Yeah, we do see this kind of situation when we get into where the persons have done some criminal activity, have something major things. Normally, when a change of status, like for example, if an F1 student visa might have violated a status here and there, or probably sometimes when there is a gap period of the H-1B where the person is not paid for a month, we have never seen the notice to appear, but we did see the notice to appear for the immigration proceedings when there is some a major fraud or anything like that. Not in the case when the person did not get pay stub and the change of status or extension status is denied, their H-1B is still approved. But do you think so, Emily, right now, based on this new memo, that when we get the change of status or extension of status is going to be denied, we're going to have a problem? They're going to be issued a notice to appear in front of the immigration judge?
So it's important to understand that this is not going to be in every case. The only situation where a notice to appear will be issued in employment-based cases is if there's an application denied and the person is unlawfully present. So if you have a valid I-94, there's never been an overstay of your I-94, there's no unlawful presence, which means this memo does not really impact you. So the issue would be, the most common situation, for example, would be an H-1B extension was filed on time, the underlying or previously approved petition has expired while the extension was pending. In that situation, the person can continue to stay in the country and work in a period of authorized stay. We also call that post-bag. They can continue to stay and work while the extension is pending, even after the I-94 is expired. Totally legal to do that. But now this new memo says if eventually your extension gets denied, on the day of the denial, you are out of status and you are unlawfully present because your I-94 has expired. Now, they will issue a notice to appear in that situation. Before, that never happened, unless there was some other major issue, fraud, criminal activity, or something like that. So now we're in a situation where a denial of an extension, a denial of a change of status, when the person's I-94 has expired and now they're unlawfully present, will lead to an NTA. Now, we don't know how long it will take for that NTA to be issued. We do know in the denial notice they've kind of changed the language recently to where it will tell you that this decision leaves you without status, you are now accruing unlawful presence, therefore you must depart the country immediately. It doesn't give you a grace period. There's no 30 days to wrap up your things and leave. It says immediately. So I would hope that the government will give people time to leave, and then only if they don't leave, they will eventually issue a notice to appear. We don't know, though,
We
right?
don't know yet, yeah. When the notice to appear happens, the major issue, that problem that will arise for the people is that you can't just leave the country. I mean, when you're determined to be out of status, normally what people do is at least those people who wants to comply with the law, they just leave the country because they don't want to stay undocumentedly in this country for a long period of time. But once the NTA has been issued, you leave the country, you will get a deportation order in absentia. So in other words, you'll have to hire a lawyer, you need to deal with the immigration, you need to get the permission from the immigration before you leave the country. It's an extra burden. I don't know why the Trump administration is trying to burden themselves with putting all these people in the deportation in the removal proceedings, when they actually, a lot of these people will be willing to do that. In the memo, they did not clarify that they will give a certain time for this period to leave the country. And they're just saying that we may issue the NTA, but they have not clarified. Emily, is there any further guidance that the USCIS is proposing to issue on this so that we can make our people aware what to expect, what not to expect?
Yeah, so this memo went into effect, June 28th, I think. Clearly, we've not seen any NTAs issued yet as a result of this memo. And the reason for that is the memo or the policy guidance instructs the service centers, who are generally the ones that issue denials of employment-based extensions or changes of status. They've instructed the service centers over the next 30 days to come up with their processes and procedures for how they're going to handle this new task. So I would expect we won't see anything happen over the next 30 days. After that, I'm hoping that we'll have some additional guidance from USCIS or from the Service Center operations that will let us know exactly what they're intending to do before they start issuing NTAs everywhere.
And then Radio Newman PC, in our news livecast, we will update you of any new developments on that. I want to go to the question that is relevant to it. Mr. Raman has this question. My H-1B extension is coming, but my end client is not going to give a letter. And if my H-1B extension gets denied and my I-94 expired, will I get an NTA notice to appear in the removal proceedings?
Yeah, it is possible, especially if the denial happens after your I-94 has expired. Now, I wouldn't say that you should avoid filing the extension. I think that you need to just be aware of the potential for that. File early enough, file in premium processing so that if there's a denial, it happens before your I-94 expires. In the situation where an H-1B extension is denied, but your I-94 has not yet expired, you can continue to stay until your I-94 expires, and you have the opportunity to file a new extension, refile it with better documentation. Maybe the end client will be more willing now that they see that you ended up with a denial last time around, or maybe you're eligible for some other type of visa. You could file a change of status. If you end up after your I-94 has expired and got that denial, not only are you out of status, unlawfully present, now you have the risk of an NTA. We've been advocating for quite some time. I think every week on this show, we tell people, file your extension early, file it in premium processing, don't wait, don't reach the 240 days.
Don't.
Get it over with before your I-94 expires, because yes, we are seeing an increase in denials of extensions. Things that we would get routinely approved before are being second guessed now. So you need to be prepared for that and put yourself in the best situation to where you'll actually be able to overcome it if the worst case happens. If you wait too long, get it denied after your I-94 expired, it's going to be a much bigger headache to come back from that kind of denial.
And then once you have the I-94 validity, even if your extension gets denied, there will be a lot of options that you might have. You can file one more extension, you probably can apply for one more transfer, you can apply for any other visa status that you might be eligible if the I-94 validity is there. That's the reason why we advise people to get the decision as soon as possible rather than wait. And the rumor that is spreading is the biggest lie, that the premium processing, if you file in premium processing, you tend to get more RFEs, you tend to get more denials, is an absolute lie. Do not believe in. Emily, I want to also educate our audiences with regards to this CPT, the day one CPT, after they have completed the master's degree, they used up the OPT, they might have used up the STEM extension. Now they joined another university with the master's degree and got a CPT. Now, as we have educated our audiences before, that there is a memo, a different memo, not the same memo that we are speaking about, that went in effect on June 28th, but there's a different memo which is effective on August 9th. And there are some troublesome aspects that I want to address to you, Emily, is that what it says is that if a change of status has been denied from F1 to H1B, then if the USCIS has determined that the violation of the F1 status occurred before, previously, when the denial comes in, from the date of the denial, they are accruing the unlawful presence. But this memo tells a complete different story, which is becoming effective on August 9th of 2018. Can you educate what this memo is, how it's going to affect for those people whose change of status might be denied because of the CPT issue?
Right. So the CPT at the same degree level, we have an interpretation of an existing regulation that suggests that's not allowed if you've already used up your OPT time. You can't go back to school at the same degree level and get CPT. Because of this changed interpretation, we're seeing that USCIS is making the decision that that CPT, even though it was authorized by the school, was not actually authorized by the regulations. Therefore, it was a violation of F1 status. As of today, that means that from the day that decision happens, going forward, you're out of status and accruing unlawful presence. On August 9th, that will change. Now they're going to say, not only are you out of status and unlawfully present today, you are accruing unlawful presence from the day you started the violation, which would be the day the CPT began, going forward, which means that many people use the CPT for months, some even years. So if you've been doing the CPT for over 180 days, and now there's a decision that that CPT was not authorized, you've now been unlawfully present for over 180 days, now you're subject to the 3-year bar. So this is under the new memo that's supposed to take effect August 9th, assuming that nothing has changed in that guidance. So we have a lot of very anti-immigrant things coming at us every day. It seems like we need to take these things very seriously and make sure that we are in perfect compliance in H1, in F1, OPT, CPT, L1, every single status. You've got to be extra careful to make sure that you're not going to end up not only unlawfully present, but now under this new guidance, getting an NTA and put into removal proceedings for it.
Emily, on top of this burden, there is another thing called STEM extension. As you guys are aware that OPT has been given after you complete your bachelor's or master's degree for a period of 1 year, and if you have a STEM degree, you're eligible for a period of 2 years on the STEM extension. There is an update on the USCIS website that is indicating that the STEM extension people cannot work at a third-party location. Now, this is just a website update. This is not a regulation. This is not a rule. This is not even, there is no memo, there is no comment period, nothing has been issued. But we have noticed that USCIS is now issuing RFEs for the H1Bs for those people who have been working at third-party location. We have also noticed that some of the universities wanted the 983s to be filed again so that the STEM people do not work at third-party location. What is the interpretation on this, Emily? What do you expect going forward on the STEM extension? What about those people who have already worked on the STEM extension at third-party location? They were not aware of these rules. We never educated those people you cannot work at third-party location. No other immigration lawyer ever told that, and all of a sudden the website is telling you cannot do it, and we have RFEs and we don't know how the things are going to turn out.
Yeah, it's a really difficult situation for students and employers who've already relied on existing regulations and thought this employment was authorized. They've got their 983 filled out, submitted to the school, were approved for the OPT STEM extension, and now they're being told that work, that you can't place someone there. And on top of that, we're getting requests for evidence in the H-1B asking how did you maintain your F-1 status if you were working at a third-party site, because the USCIS website says you can't do that. And so we're in a situation where for students you have to decide whether you're going to try to fight back and respond to that RFE with arguments that this is just a website update, there's no basis in law or regulation, my work was properly authorized there, and then you risk the potential for a denial of the change of status, a determination that you violated your STEM OPT, which leads to a determination that you've been unlawfully present the whole time you were on STEM OPT, and now an NTA. Or option 2, you may want to consider consular processing your H-1B, avoiding the status questions altogether. Now that does mean once your H-1B is approved, you do have to exit the country, go to your country for a visa interview and get the visa stamp before you can come back and begin working in H-1B status. So there is that added burden there. And it's a tough call. I mean, these are students, early in their careers, many of them having to make these important life decisions with no guidance at all from USCIS, or the guidance that comes out is completely contradictory to what we were told before. So I really feel for these people that are stuck in this situation, not knowing which way to turn, because we don't know which way to turn at this point.
What we tell today is not becoming true tomorrow, and they're telling, we told people that you could work at third-party location and everything was going through smoothly, and now all of a sudden the USCIS is telling, well, no, that's not true. You cannot work based on the website, not on the rules.
Yeah. I think this is something that employers are going to have to litigate. Those employers that do third-party placement, if they want to continue to have access to STEM OPT students, they're going to have to file a lawsuit to get this website changed back.
In fact, I just finished the draft of the litigation that's to be filed. We're expecting the litigation to be filed tomorrow on the 983 and the third-party location worksite. Emily, all these bad things are going on with this administration. Do you have any good news to give for this in this administration?
I'm not sure I do. The only somewhat good news is on the H-4 EAD front, there is still nothing submitted to OMB, which means no news is good news. We can continue to carry on as is. The regulation that we're expecting that will rescind the H-4 EAD has not been proposed yet. It's not been submitted to OMB, which means it's going to be delayed even longer. It was supposed to be proposed in June. We're now into July. Because it has not been submitted to OMB, I don't expect it to come in July either. It's probably going to be August at the earliest. So if this keeps getting delayed, it's better for those that are on H-4 EAD. They can keep it a little bit longer.
And so right now, if you're on H-4 EAD, you could file for the extension. You could file if you're filing for the first time. And if you're working on the H-4 EAD, you can continue working on the H-4 EAD. That's not a problem. Even if any proposed regulations are going to come in, the effective date of that will be a little bit way further away. Last time when they tried to pass the H-4 EAD, it took almost 1 year. We are expecting, even when the proposal comes in, by the time these things will become effective, it might be a long period of time. The one good news that I might suggest is that there are a lot of employers and employees that are going to the federal court. Our office is supporting and also helping the litigation lawyers in organizing the in the complaint. We're expecting some positive results coming from the court system, because we do believe that a lot of these activities done by the Trump administration is completely illegal according to the law and also according to the regulations that they have passed. So we do expect some resistance coming from the courts. That's the only thing. Emily, on the HR 392, what are the likelihood of chances of that to be passed, having been that there is no major immigration bill that has ever been passed since 1996, which is IRA, which is actually not a major immigration bill. The major immigration bill was in 1985 when the I-9 was being introduced and amnesty was given at that point of time. From 1985 to right now, no major immigration bill, and then somewhere in 1996, which became effective on April 1st of 1997, there was an IRA bill. Nothing has been. What are the chances for this HR 392 to go through right now?
Yeah, I think it's still got a long road ahead of it, and you've got to also remember that that's just in the House. So even though we have all these co-sponsors, we also have to get something done in the Senate, and neither side is looking to do anything anytime soon. I do think it's incredibly important to keep pushing for it. Don't give up just because it's not happening, just because it didn't happen before. Imagine how long the Dreamers were pushing for something for them. It's been decades.
Yep.
And they finally did get DACA, which was a temporary fix and done by executive action. But they're also still pushing for relief on their side. You should continue to do the same. Even if the chances don't look good, you've got to keep pushing for it. It is absolutely vital if you ever want to get a green card before you retire.
Senator Reid, who was the majority leader in Senate when in Obama administration, who was also a Democrat, wanted to pass the legislation with regards to the Dreamers. He cried on the floor of the Senate to pass the bill. They didn't pass the bill. So this Congress, this Parliament which is there, doesn't look like they want to pass anything. So I would not keep much high hopes, but keep trying. Maybe the administration will change. Maybe things will change. Maybe they might come up like the way, even though there was not a law passed in the Senate, Obama administration was able to get the Dreamers, the employment authorization card. So some things you might get, if not this administration, maybe the next administration. I want to go to quick questions, Emily, with regards to Prashant has this question where his I-94 validity has been given lesser period of time than on the H4 than that of the H4 approval that he had. Does he need to fix it? Does he need to just don't worry about it if I-94 is expiring? You better need to fix that one. If your I-94 is expiring, even though your 797, which is the H4 approval, was for 2020, and if your I-94 is expiring in 3 to 4 months, you need to extend that. Otherwise, you will be in trouble.
So, options for correcting the situation. Option number one, if it truly was an error by CBP at the port of entry and the I-94 has not expired, you can go to Deferred Inspection Office of CBP and request a correction of your I-94. That's option one. It may or may not work. Option two would be to travel outside the country before your current I-94 expires and come back in and make sure they give you the new I-94 to the longer approval notice of the H4. Option three would be to file an extension of your H4 status from the time it expires, September 2018, going forward till the time the H-1B spouse expires. So you do have options to fix it, but make sure you fix it before
the I-94 expires.
That's very important.
I am on H-1B visa. My wife is on H-4 visa. This is a question for Mr. Roy. And can I stay in India for 1 year? My wife can stay here on H-4 visa for the 1 year period. I don't think so. That looks to be legal to me, Emily, because if the person is absent for a month or two where he has taken a vacation, maybe some family emergency, went outside the country, that looks to be okay for the H-4 person to stay here. But 1 year period outside the country, H-4 staying here, I don't think so it's legal. One of the reasons is that the only reason why H-4 is being given is for the H-4 person to stay with the spouse of the person, and if the spouse is absent for 1 year, why are you in this country?
Right, and also the H-4 status is dependent on the H-1B status. So if the H-1B is not in the country, they're not maintaining any status, which very likely puts the H-4 out of status.
Suppose a person is already left the country, get the denial. If the NTA has been issued, what happens at that time? If the NTA has been issued and you got the denial, you got the denial after you left the country, and the NTA is been issued after you left the country, I think so it's easy to deal with the USCIS to go inform the USCIS, look, my client has already left the country, so this notice of appear is not applicable. It might, you still need to hire a lawyer to deal with this issue, but it doesn't look like it's going to be a major problem to deal if you have already left the country. But if you are in the country and then you are planning to leave after the NTA has been issued, that becomes a problem.
Right. One question that I get a lot on the blog about this new NTA policy is, what is considered a denial of an application or a petition for a benefit? So what if my I-140 gets denied? Am I going to get an NTA? What if my 765 gets denied?
Let's go one at one. If the I-140 is denied, you should not be getting an NTA unless there is some major fraud involved in it. If you just I-140 is denied because of some degree mismatching, or the experience is not sufficient, or the company doesn't have enough resources to pay the salary, I don't think so. You will be getting the NTA. Now, when you said 797 extension has been denied, 765, which is employment authorization document. Well, if it is a STEM extension, though, that might be an issue. That could be an NTA. 765 could be for different purposes. If it is for a H4 EAD, 765 has been denied. I don't think so. That should be a cause. If it is for a STEM extension, and the STEM extension has been denied, that might be an NTA cause. NTA can be issued when you apply from F1 to H1B, and the USCIS does not consider that you maintain the F1 status. They may issue they may issue the things. They may issue an NTA, and the NTA may also be issued when you file a change of employer from company A to company B, and the gap period between employer A and employer B is more than 60 days. The NTA might be issued.
If your I-94 is expired.
That's right.
Yeah, I think a lot what this boils down to is it's not just a denial that causes an NTA. It's a denial plus unlawful presence. So if there's no unlawful presence and then you get a denial that doesn't make you unlawfully present, then there shouldn't be an NTA issued. But if the I-94 has expired and a denial occurs to where you're unlawfully present, that's the biggest area of concern.
And one thing is that typically, if you, I-94, you address that issue. If the I-94 is expired, and you get the denial. That's the spot on the thing. So make sure that your I-94 does not expire. Try to do the premium processing, get the result as early as possible.
On the I-94 topic, I'm still amazed at how many people don't realize that when they travel and come into the country, they have to go online and get their new I-94. Like every day I talk to someone that didn't realize that website existed and is going based on the I-94 that maybe they got with an I-797 approval. But like the gentleman asked earlier about getting that shorter I-94 when they came in, what if he had not looked on the website? That happens quite often.
That happens quite often.
So every time you travel, go to the CPP website and pull out your new I-94, check the date, see what the expiration date is. It's very possible it could have been issued wrongly to where you can get it corrected. Sometimes it's based on your passport expiring that they might shorten it. So you really need to keep an eye on that and always check it every time you re-enter so that you make sure you don't end up overstaying unknowingly.
And sometimes what happens, Emily, is that when the passport validity, let's say, is, for example, until September 2018, the visa validity might be 2019, and they only get the I-94 until September of 2018. That's the major problem we see. But for any reason, as soon as you enter into the country, check your I-94. If you have any inconsistencies or if you have any problem, it's easy to rectify when your I-94 is not expired than compared to when I-94 is expired. And also, please do not forget to file the H-4 visa when their I-94 is expiring. Just by filing your H-1B, it's not enough. Also, if you applied under the quota right now, and you have not applied for the H-4 visa, and your H-1B has been selected, please file the H-4 immediately. Don't wait until October, because once you enter into October, you get the H-1B approval, the person is undocumented if the person is an F-2 or any other visa status. So please file the H-4 right now itself in the quota.
One other question I've been getting a lot, especially on the STEM OPT third-party placement issue. If someone already has their STEM OPT approved, and maybe for the last year they've worked at a third-party site, can they cure it by just going to work at a new employer or working in-house for the existing employer? Is there a way to cure it once the violation happened? Can you unring the bell?
Well, I would, if you have an option of going and working at the company location, I would tell people go do it. If instead of working at a third-party location, you have a job to do it at the direct location, I would suggest people to do it, Emily, immediately. But can you undo the things what you have done? How can you undo it? I think so. Elon Musk time capsule. It's a capsule, but it's not time capsule. Anything like time capsule comes in, we can do it, but we cannot undo the things going back at this point of time. We have to hope that litigation or probably USCIS changes their mind, won't interpret the way they are doing it right now, but we cannot undo it. But if you have an option right now at this point of time to go and join a company which has a direct job, I would, if I were the person on STEM extension, I would do it.
All right. Another question is, what is the outcome of a situation where an H-1B amendment has been denied? What is that? What options do you have? What do you need to do in that situation?
If the H-1B amendment has been denied, you can always go back to the previous job and work there. You can apply for one more amendment with the same job and work there. But please note that between the denial and filing another application for amendment, you should stop working at that location. So if the amendment, you can go back to the previous job or file another amendment. Any other things, creative solutions that you have, Emily?
Yeah, I can't think of any other options.
Emily, what are the practical solutions, Emily, when the extension is being denied and the I-94 is still valid? What do you do in that situation, Emily?
I think you have 3 or 4 good options. Option number 1, if you think you can overcome the grounds for denial, you can refile the extension before your I-94 expires. Better documentation, better job description, different SOC code, different wage level. There's lots of things you can change to try to overcome the issue in the previous denial. So that's option 1. Option 2, you can file a transfer to a new employer as long as the transfer is filed before the I-94 expires. And you can begin working for the new employer as soon as that petition is filed. Option 3, you can file a change of status to another type of visa if you qualify for one. Option 4 would be to stay until your I-94 expires and then leave.
Why are you not suggesting to file an appeal instead of all these things, Emily?
Well, certainly you can file an appeal. The reason I generally prefer not to is the processing time is so long that you might end up accruing 180 days of unlawful presence while you're waiting.
Well, a person cannot work while the amendment is, while the appeal is pending?
Right, so the appeal does not provide you status, it does not provide you work authorization, and it does not toll unlawful presence unless it's ultimately successful. So you may sit around waiting for 6 months and then 6 months later you get a denial of your appeal. Now you've been unlawfully present for 6 months, you've been out of status for 6 months, and potentially, if you working without authorization for 6 months. Now when you leave, you may have triggered a 3-year bar to coming back. So even though, yes, you do have the opportunity for an appeal, it generally is not that helpful unless you have some other status that you have. Like if you were filing a change of status and the change of status, that petition got denied, but your underlying status is still valid, then maybe an appeal would be useful. But the processing time really, versus refiling in premium or filing an appeal and taking 6 months, I'd prefer to get the answer and get the status situated right away rather than delaying it for 6 months and then potentially ending up with an NTA after it all.
Dinesh has a very technical question, is that does the unlawful period start from the time the stem extension at the third party started, or is it August 9th? Dinesh, you're right. It starts from August 9th. Or when the denial occurred, whichever is the earliest. So if the denial occurred today, the unlawful presence will start today. It doesn't go back to the time when you started the stem extension. When you started the stem extension, you started working at third party location.
Right, and the unlawful presence does not begin unless an actual decision is made, which states that you violated your status. So if there's no decision made, even if there may be a violation, there's no unlawful presence yet.
Yeah, but the new memo will go back to August 9th. Right. Okay.
But that only happens when the actual decision was made.
That's right. If you receive an NTA after the I-94 expires, can we apply the H-1B with a different employer?
So you can for consular processing, but you've got to figure out how you're going to get that visa and get back in status. So if, for example, the NTA is issued and you work out with the attorney in the case that you want to voluntarily leave at your own expense, that's called voluntary departure, you have to get permission from the court to do that. If you're granted that permission and you leave and you've been given voluntary departure, then you have a new employer or even the same employer file a new petition for you. You can apply for the visa. If you get the visa stamped, you can come back. Now, if an order of removal is actually issued or you've left while the proceedings are going on, then you are subject to a 10-year bar, and the only way you can come back is by filing a waiver of that bar of inadmissibility, which you would also want a petition filed by your employer that helps the waiver process. So it's not the end of the world to have the NTA issued, but it's certainly a lot of extra hassle, a lot of extra legal costs. Best to avoid that situation.
Sanjay has this question that he could not find the I-94 he entered into the United States in 2012. Seems to be that something has been misplaced, but if you have entered in 2012, you might have applied for the extensions. You might have already have a 797, which is validity I-94. So you should contact lawyer, or you can come to a daily conference call that we conduct every day. You can get our daily conference call detailed rnlawgroup.com, and I will guide you how to get the I-94. But I'm assuming that since they come in 2012, they already got the extensions. Must have already 797, which has that.
Right. Yeah. The CBP website only goes back so far. I can't remember the exact date. Maybe 2014 is when that came out. So entries that occurred before that won't be in the system. So this is for more recent entries that occurred.
Will USA issue an NTA if I move to company B and then move to company C in cap gap?
Now remember, NTA is only going to be issued when two things happen. Number one is a denial of something, and number two is unlawful presence. So just by moving during cap gap, there's no indication that a denial occurred, there's no indication that there's unlawful presence. So I would not think an NTA issued would be for just those reasons. There's got to be something more. There's got to be a decision, an unfavorable decision on an application or a petition, plus unlawful presence. In that situation, and only that situation, is when an NTA is going to be issued for our employment-based typical clients.
Shruti has this question. I'm an H4 currently right now. Can I convert into F1 visa in my second or third semester? Hope that won't be a problem. Shruti, one of the issues that props up is that right now F1 sometimes is taking about 1 to 1.5 years. So if you are wanting to avail the opportunity of the OPT and STEM extension, you need an F1 for at least 1 year period though. So I would recommend that you apply immediately or you don't as a tactical purposes, because it's taking a long time to get the F1 visa. Why I ask this question, Emily, is that my H1B has been picked up and it's not approved. Can I go to India and come back on, I don't know, on what?
Right, yeah. You number one, if you filed a change of status from whatever your current status is to H1B, the change of status will be automatically abandoned if you leave while it's pending. Number two, you may not be allowed to come back in if your whatever visa you're entering on conflicts with a pending H1B. And number three, your change of status will be denied, and now your H1B is going to be converted to consular processing. The only way to activate it once it's approved is to go out again and go for H1B stamping or file another change of status, which is basically like filing the H1B all over again. So that's a lot of extra things, extra problems that you're creating by traveling during this 6 months between April and October. We don't recommend it.
Jaspir has a very good question though, is that if I have an NTA on my record, will it affect my H1B application visa? Yes. There is a column that will ask where you ever been in the removal proceedings, and you say yes, and then you have to provide all evidence. It's not a good thing to have an NTA. How can I check an I-94 has expired? That's an easy question.
Right, so you need to go online to the CBP website to see from your last entry if your I-94 has expired. Otherwise, you need to look at your I-797 approval notice from your last extension or change of status. It would be there. But I will say I've gotten this question a lot in the last couple of days on the blog, Immigration Girl, particularly for those students who are issued an I-94 with D/S, duration of status. They want to know when does their I-94 expire, because they want to know if they're going to be issued an NTA in the event of a denial. So there's kind of two answers, because right now we're pre-August 9th guidance. The one somewhat silver lining about the guidance on August 9th is it makes it very clear when the I-94 expires for people that are in duration of status. So if you are, once your program ends, if you're not doing CPT or OPT after it ends, it's the program end date plus 60 days. If you've got OPT, it's the OPT end date plus 60 days. So you have that 60-day grace period. So that is your I-94 expiration date unless you re-enroll in school or unless you receive a denial of a change of status before you get to that point. So it's a kind of a tricky answer to something that should be really simple. When does my I-94 expire? It could be varying, especially for those with duration of status, a little confusing.
I'm going to take the question of this person by name Anand. Anand means happy. That's the meaning of it. I have my I-140 approved, and I'm assuming that your I-140 has been approved for more than 180 days. How many transfers can you do on the I-140 approved for more than 180 days, and you left the company after 180 days, assuming it's after January of 2017, unlimited? You can keep on transferring on the same I-140 from company A to company B, company C, company D, company F, any number of times. And also, I just want to make sure that I-140 has not been withdrawn within 180 days. That's the only conditions. Then you can keep on going on until your life. Anything else, Emily?
Yeah, just to make clear again on this unlawful presence memo and the NTAs. The NTAs are only going to be issued when a denial happens. So just because you might be working at a third-party site on STEM OPT, or just because you might be working on a day one CPT on your second master's, does not mean you're going to get an NTA. There's not been a denial. The NTA requires a denial of an application plus unlawful presence. Same thing goes if just because you're on OPT working at a third-party site on the STEM extension, does that mean you're unlawfully present right now? No, there has to be a determination that there's a violation, which leads to unlawful presence. So there has to be some kind of decision that occurs before unlawful presence kicks in or an NTA is issued. There's I think a lot of fear out there that the government's after everybody, even if there's no denial happening. So it's not like, I don't know what I'm trying to say. It's not as bad as you think.
At this point of time, it's not that. Don't expect that every denial is going to be an NTA at this point of time. We don't know how the USCIS is going to act, but we will inform you in the coming weeks and when and if they issue NTA. As of now, no NTA has been issued for the change of status denial or extension of status denial as of now. But we will be updating you when and if the NTAs have been issued. We just want you to be watchful about the NTA, not that right now panic and run away or something like that. Any of you guys, we couldn't answer the questions. There are too many people. We couldn't answer all the questions, but you can always make an appointment either with me or Emily at rnlawgroup.com, with me, Emily, or any of our other lawyers that we have. Also, please, you can always check Emily's blog at immigrationgirl.com, and we also post our news at RN Law Group news section. Anything else, Emily?
All right, thanks for joining us for today.
Thank you.